Who's going to kick off?
Your Lordships, my name is Mr. Cotton, and I'll be making submissions on behalf of the appellant, along with my learned junior, Mr. Bariani. My learned friends, Mr. Dory and Mr. Morallum, will be making submissions on behalf of the respondent. Would your Lordships like a brief summary of the facts that led to today's hearing?
No, I think we can. We've got that in the bundle, so you can skip straight to your arguments.
Then I will move to my first ground, my submissions to my first ground of appeal, namely that with consideration to Caparo and Dickman, it was foreseeable that Mr. Dashing would act on the threats sent. I will now move to my first submission, that in terms of the first limb of the Caparo tripartite test, the harm caused to Miss Pretty was foreseeable, as the police were informed of the threats made and previous actions involving domestic abuse. If I could direct your Lordships to the case of Warhill and Young, 1943, in the Law Courts Appeal Cases, 3rd Series, page 92.
Thank you, I've got it.
I'll be quoting from the judgment of Lord Wright, who states that this general concept of reasonable foresight as the criterion of negligence or breach of duty, strict or otherwise, may be criticised as too vague, but negligence is a fluid principle which has to be applied to the most diverse conditions and problems of human life. It is a concrete, not an abstract idea. It has to be fitted to the facts of a particular case. Your Lordships, I submit that from what Lord Wright is saying here, it is clear that there is no strict test for whether something is foreseeable. It is merely dependent on the facts of the case. I submit that on the facts of this case, it was foreseeable for the police to have realised that Mr. Dashing would have carried out his threats, due to being notified both of the threats and of his previous conduct.
Yes, but of course foreseeability is not the only criterion for liability and negligence, is it necessarily? Because if you merely had a test of foreseeability, that would really open the floodgates to a never-ending stream of litigants, wouldn't it?
Indeed, my lady. As I'm sure you're aware, there are 3 parts to the Caparo tripartite test.
Yes.
Foreseeability, proximity and fairness, justice and reasonableness. The last points of which my learned junior will be addressing.
Yes, sorry, please proceed.
This test is elaborated on in the next case, that of Glasgow Corporation and Muir, 1943, in the Law Courts Appeal Cases, 3rd Series, page 448. Would your Lordship care for a brief summary of the facts?
You're looking at the reasonable man.
Indeed.
No, that's okay. You can move on.
In particular, I address your Lordships to the judgment of Lord Macmillan, who elaborates on the Warhill case, who states that a reasonable man is presumed to be free both from over-apprehension and from overconfidence, but there is a sense in which the standard of care of the reasonable man involves in his application of subjective development. It is still left to the judge to decide what, in circumstances of the particular case, the reasonable man would have had in contemplation, and what, accordingly, the parties sought to be made liable ought to have foreseen. Your Lordships, I submit that in this particular case, for the reasons I stated in for the first case in my submission, that the police should have foreseen, it would be reasonable for the police to have foreseen that Mr. Dashing would have acted on these threats. Indeed, it is clear that they had foreseen that something would have happened, as they did to make a positive act to go and investigate the situation. Something that my learned junior will address later.
You're making an assumption here that the police knew about this chap's previous.
Indeed, my lords, it is stated in the case facts.
Well, it says that there was a hearsay conversation between a previous girlfriend and the current girlfriend. It doesn't say anywhere that I've seen, unless you can take me to it, that was actually reported to the police.
My lords, after the conversation with the ex-girlfriends, it states that Mrs. Pretty made a second police report talking about this, and also the threatening packages that were sent to the house.
I'm sorry, I might have missed it, but I'm glad if I can see that.
My Lord, is in halfway through the third paragraph of the case facts.
Mrs. Pretty made a second police report against Daniel and urged them to investigate the matter.
Indeed.
It doesn't say what she said in the report.
However, I submit that it can be implied from this that that's the only thing that had changed since the last report. Therefore, it is implied that that's what she told him.
But haven't the teddy bears changed as well?
Indeed, my Lord. However, it is. However, I submit that it is implied that both things were told to the police.
All right, Mr. Cotton, thank you.
Your Lordships, I also submit that Lord Macmillan's statement that the reasonable man is free from overconfidence and over apprehension. It is not overconfident to believe that there was no risk to Miss Pretty. Indeed, their actions to go and investigate the situation showed that they did think that there was some possibility of harm. Do your Lordships have any further questions on this submission?
Well, the only thing I would comment was Lord Macmillan in the Glasgow case he goes on to say, after your highlighted passage, there is room for diversity of view. What to one judge may seem far-fetched may seem to another naturally probable. So it suggests that there is a sort of there is a range of sort of reasonable judicial decisions in relation to the issue of reasonableness.
Indeed, my Lord.
And the court wouldn't necessarily overturn a judge's view.
Indeed, my lady. It is a subjective element because the judge is looking at what he believes a reasonable man would have thought. However, I submit in the current case it is quite clear that that there was a clear possibility, distinct possibility of Mr. Dashing moving on to make further physical violence after the threats, and also that coupled with his previous history of domestic abuse. Do your Lordships have any further questions? Then, with your Lordship's permission, I shall move to my second submission. Your Lordships, I'm aware my time has expired. May I briefly...
Well, we've kind of eaten up your time, so if you go on to your next point and deal with it reasonably swiftly.
Thank you. My second submission is that the current case is distinguishable from the principle in Van Col, as Mr. Dashing had a history of domestic violence, rather than there being one unforeseeable irrational decision. Therefore, his actions were foreseeable. If I could direct your Lordships to the case of Van Col and Chief Constable of Hertfordshire, 2008, in the United Kingdom House of Lords, page 50. Would your Lordships care for a brief summary?
Yes, please. It can be very quick.
Your Lordships, this case involves two separate cases. Firstly, the case of Van Col, where Mr. Van Col was under pressure not to testify for a theft. He then went to testify to with the police and told them of the threats. However, after this, he was shot. The second case involved Mrs. Smith, who received threatening messages from his ex-boyfriend. He told the police, and then his ex-boyfriend murdered him with a claw hammer. If I could direct your Lordships to the judgment of Lord Hope, who states that the murder was the action of a seriously disturbed and unpredictable individual. In my opinion, it cannot reasonably be said that Detective Constable Ridley should have anticipated, from the information available to him at the time, that Boreham constituted a risk to Giles' life that was both real and imminent.
But isn't that very much comment on the facts of that individual case? What are we to extrapolate from that as a general principle?
Your Lordships, I submit that in that case it was stating that actions of extreme violence such as murder, the court in such cases the court will not look at whether it is foreseeable due to the fact of such an irrational mind that would carry out such an action. However, I believe that the current case is distinguishable, as there was a lesser offence of battery, and I submit that it was reasonably foreseeable that a man of Mr. Dashing's character would have followed through with these threats in the circumstances.
Doesn't Van Cole, in fact I know it does because I can read it to you, it says that the police knew or ought to know at the time of the existence of a real and imminent threat to life. Are we suggesting that there was a real and imminent threat and they failed to take any reasonable measure?
My lords, I submit that yes, there was a real and imminent threat. If I could address a case that is not in my skeleton. The real and imminent threat comes from the case of Osman and Ferguson, and it is under Article 2 of the European Convention on Human Rights. I submit that in this case there was a real and imminent threat due to the nature of the threats sent to Miss Pretty, and also his past history.
A real imminent risk to life?
Indeed, my lord. Also the fact that I submit that the fact that the police went to Mr. Dashing's house and he was not there, it could have been inferred that he had gone to Miss Pretty's house to see her, seeing that the police knew the situation.
Or he could have popped down to the bookies.
Indeed, my lord, but however, I submit respectfully that in this situation, the police should have realised that I should have taken precautions.
Thank you, Mr. Cole.
Do you want to have any further questions? Then I shall hand over to my learned junior.
Your Lordships, I would make submissions on the second ground, on the basis that there is indeed a duty of care, based on that there be fair, just, and reasonable, and not only would it not lead to defensive practices, but practices to preserve human life. Your Lordships, if I may refer you to my first ground, that the police were informed of the threatening messages made to Mr. Dashing by Mr. Dashing, and of his previous history of domestic abuse. This case is distinguishable from the Hill principle because the police took positive measures to investigate this matter. If I may refer your Lordships to the case of Hill and Chief Constable of West Yorkshire, 1989, in the Law Reports Appeal Cases, 3rd series, on page 53. Your Lordships require a brief summary.
No, this is the Yorkshire Ripper case, isn't it?
That's correct.
Yeah, but in that case it was a very generalised threat to women in the area, wasn't it? From
That's
having
correct.
a mass murderer around.
That's right.
Here, I suppose you'll be arguing it's a more specific threat.
That's correct, Your Ladyship.
Yeah.
If I may refer to your Lordships to a quote by Lord Templeton, he says, "If this action lies, every citizen will be able to require the courts to investigate the performance of every policeman. If the policeman concentrates on one crime, he may be accused of neglecting others." Your Lordships, in this case, the police took positive measure to investigate this crime, and they did so negligently. They went to the house of Mr. Dashing and then proceeded to do nothing.
Well, you can go further than that, can't you? Because it wasn't a generalised threat of having an attacker in the neighbourhood or a rapist or a murderer in the neighbourhood. It was a much more specific threat, wasn't it?
That's correct, my lady. They knew the name of the attacker and who would it occur to. This was very specific. And Lord Templeton says that if they omit, if there is a pure omission, they can attend to other causes. However, in this case, by taking positive action, they have eliminated themselves from being able to help someone else. So by taking that positive action, they must do so thoroughly. They must do to the best of their performance. And it would be not a stretch of the imagination to say that they should have gone to Miss Pretty's house to ensure her safety, as there was a real and imminent threat, as my learned senior has said. If I may refer your Lordships to my second case, Michael and others, and the Chief Constable of South Wales Police and another, in 2015, in the second volume of the Weekly Law Reports on page 343.
Can I just say to save time on everyone's part, I'm happy to dispense with full citations. If you just tell me the case, you don't need to give the full citation.
Of course not.
Thanks.
Would you require a brief summary of this case?
No.
If I may refer your Lordships to a quote from Baroness Hale.
Yeah.
She says, "The necessary proximity is supplied if the police know or ought to know of an imminent threat of death or personal injury to a particular individual, which they have the means to prevent."
Well, Baroness Hale was in the minority, wasn't
She was a
in this
dissenting
case?
judge. Once that proximity is established, it is fair, just, and reasonable to expect them to take reasonable care to prevent the harm. In particular, the interrelationship between the special status and powers of the police to prevent crime and protect people from harm, and the limits placed by the law on the ability of people to protect themselves. Your Ladyships, Lordships, Miss Pretty was not able to defend herself in an adequate manner, and thus she relied her safety on the police, and they should have done an adequate job once they were informed of the nature of Mr. Dashing.
Are you suggesting that the police accepted responsibility? Because if we look at the lead in this case, it said that there comes a point where police accept responsibility, and if they haven't accepted the responsibility. So what point do you say the police accepted responsibility for this young lady's welfare? Are you saying that this was at the point where they took a trip round to Mr. Dashing's house?
At that point, they had realized that they should have had adequate measures to protect her. And so at this point, they have accepted responsibility for the safety of Miss Pretty.
I think that's perhaps a bit of a jump, but carry on.
Your Lordships, if you have no further questions on my first ground, may I move on to my second submission, please? Your Lordships, on the basis of the Article 2 rights, her right to life and security, it is the requirement of the police force to protect her and to ensure her safety. If I may refer your Lordships to the case of Osman and United Kingdom, year 2000, volume 29 of the European Human Rights Reports, on page 245. Would your Lordships care for a brief summary of this case?
No, I think we know this one pretty well.
If I may refer you to a quote by Judge Lopez Roca. He says, "In my opinion, it is not possible to say, as the government did, that there was no causal link between the failure to take preventative action of which the authorities are accused and the events that occurred. A quite different approach is required to determine liability for an omission from that required to determine liability for an act. The former must be determined according to generally accepted rules. It has to be decided whether the assault originated from the failure to take a particular measure or measures where the assailant's previous behavior already pointed to a likelihood that he would act aggressively towards someone of whom he was particularly fond."
But again, this is a dissenting judgment, isn't it? Because the majority found there had been no violation of Articles 2 and 8 of the Convention.
That's correct, Your Ladyship. However, these rulings by these judges are very convincing because the facts...
Well, they didn't convince their colleagues.
That's however, in this case, in the Court of Appeal, I find that a judge, Lopez Roca, can be very convincing. Your Lordship, it's come to my attention that I have run out of time. May I be granted a few more minutes?
Yeah, if you just finish it. But I mean, isn't the problem that under Section 3 of the Human Rights Act, we're required to take into account judgments of the European Court, but of course we need to take into account the judgments of the majority as well, which go against you.
That's right, Your Lordship. However, I find that Judge Lopez Roca has a very convincing argument, and that many judges in these cases of police negligence say that this will later involve defensive practices if we were to involve a duty of care. However, I submit, Your Lordships, that there already is defensive practices going on. It's defensive practices encouraging them to protect their own liability instead of protecting Article 2 rights of safety, of life, and security.
What evidence do you have for defensive practices?
Your Lordships, in many cases it comes up that it would open the floodgates for further litigation against police forces. However, in cases where there is clear foreseeability, where it is clear that something bad could happen to Miss Pretty or any individual, it is clear that the police must take action to prevent any detrimental harm to an individual. Therefore, by omitting impure omissions, it is almost protecting their own interests rather than the interests of the citizens of the state. Therefore, Your Lordships, I ask that you, if you have no further questions, I ask you find in favor of the appellants.
I will be making submissions with respect to the respondent's first ground for denying the appeal, namely that there is no duty owed by the respondent to the appellant because it was unforeseeable that Mr. Dashing would have acted on his threats. I would like to begin by referring your lordships to Caparo Industries versus Dickman. I've included in our bundle at link 1, and the relevant excerpt is at page 17. Would your lordships like a brief summary of the facts of that case?
Right, we'll know this one, thank you.
In Caparo, Lord Bridge said, "What emerges is that, in addition to the foreseeability of damage, necessary ingredients in any situation giving rise to a duty of care are that there should exist between the party owing the duty and the party to whom it is owed a relationship characterized by the law as one of proximity or neighborhood, and that the situation should be one in which the court considers it fair, just, and reasonable." It is this three-pronged test, foreseeability, proximity, and fair, just, and reasonable, that is a requirement in establishing whether there exists a duty of care. In the case at bar, even if we establish that there is proximity between the respondent and the appellant, the analysis does not end there. We must also assess whether or not the harm is foreseeable. The issue of whether or not foreseeability can be satisfied in cases like this is subject to whether or not there exists a real or immediate threat to the claimant. I refer your lordships to Osman and United Kingdom, which I've included in my bundle at link 2. The relevant excerpt is at page 110.
Yes.
Would your lordships like a brief summary of the facts of that case?
No, Osman's a very well-known case.
Uh,
I'm familiar with it.
Okay. In Osman, the European Court of Human Rights held that where there is an allegation that the authorities have violated their positive obligation, it must be established to its satisfaction that the authorities knew or ought to have known at the time of the existence of a real and immediate risk to the life of an identified individual or individuals from the criminal acts of a third party, and that they failed to take measures within the scope of their powers which judge reasonably might have been expected to avoid that risk. In the case of
You heard what Mr. Cotton said when I asked him about that very point. What do you say to his reply?
My lord, I would say, in the case at bar, there was nothing before the police that would suggest that there was an imminent risk. The details that were provided to the police don't suggest a time or a place or any details that would lead a reasonable police force to believe that something was imminent to happen.
But there was a specific fear of violence from an identified person, wasn't there?
There was, my lady, but in the case, I wouldn't suggest that a prior case would necessarily mean that further violence is to occur.
But in the context of domestic violence, realistically, if you have a relationship where you have a male partner who starts beating a female partner, doesn't past experience and history tell us this is likely to lead to future trouble along similar lines?
I would suggest that, I would submit that there was no violence by Mr. Dashing on the appellant in this case. There may have been past violence, but there was no violence in this particular case, which would lead police force to believe that it would happen again or happen at all. May I continue with my submission?
Yes.
If a duty is found to be owed, which resulted in the requirement that police treat all complaints of a potential threat as a real and immediate risk, then the result would be a divergence of important police resources away from the public and would ultimately lead to over-defensive practices which are a costly venture in themselves. This will be addressed in more detail by my junior counsel, Mr. Marlin, in his arguments in support of the second ground for denying the appeal. I would now like to refer your lordships to Michaels and others and Chief Constable of South Wales Police at link 3 of our bundle, and the relevant excerpt is at page 169. Would your lordships like a brief summary of the facts of that case?
No, thank you. We're familiar with the case.
In Michaels and others and Chief Constable of South Wales, Lord Tolson says, English law does not, as a general rule, impose liability on a defendant for injury or damage to the person caused by the conduct of a third party. The fundamental reason is that the common law does not generally impose liability for pure omissions. Lord Tolson does go on to acknowledge there are 2 exceptions to this rule, one of which when somebody assumes a positive responsibility over a claimant, and secondly, the second exception being where the defendant has control over a third party. The facts of the case at bar place it within those in which liability should not be imposed. It does not fall within either exception recognized by Lord Tolson. With respect to the first exception, the police took reasonable steps to investigate the complaints by taking down details and events leading up to the assault and even attempted to interview him. At no point did they assume responsibility for the welfare of the appellant. At no point did they lead her to believe that they were taking additional steps to protect her. With respect to the second exception, they had no control over the third party. They weren't even able to speak with him.
Of course, in this case, the minority, Lord Carr and Lady Hale, took an approach rather more favourable to the appellants in this case, and the appellants suggest, I think, that we should follow their approach rather than the majority. I wondered what you had to say about that.
I think it would be unjust to assume that any contact by a claimant or a complainant to the police to be treated as, or if a complaint were to come in, I think it would be unjust to say that they've assumed responsibility over that person. I think it would take more than a complaint for the police to assume responsibility.
Is that your opinion or is that your submission?
That is my submission. May I continue with my submission?
Yes.
I submit that the test of foreseeability as set out in Caparo is not met in this case. Threats to the appellant did not amount to a real and immediate risk, and the case does not fall within the 2 exceptions recognized by Lord Tolson. As a result, no duty was owed by respondent to the appellant. Do your lordships have any further questions on the points I raised?
Oh, thank you.
In the absence of any further questions, I request that the appeal be dismissed.
Are we going to hear from your co-counsel?
It's your lordship will not hear from my junior counsel, Mr. Moello.
Lordships, I will be making submissions on the second grounds of appeal, namely that it would not be fair, just, and reasonable to impose a duty of care on the police. Doing so would result in defensive practices. My first submission, your lordships, is that police officers have discretion as to how their resources are deployed. If I may direct your attention to the case of X and others in Bedfordshire County, which you will find in your bundle, link 5, page 343. Would your lordships like a brief summary of this case?
Yes, please.
So in this case, it is a combined appeal of cases in a public authority's negligence against the child. In one case, a child was left with the parents, causing harm to the child. In another case, the child was taken away from the parents, causing harm to both the parents of the child and the child, as well as a few cases about educational claims of negligence, in the sense that the child was needed a special education, and it was not taken into account. So claiming that the local authority failed to take the steps even though that they knew the children were at risk. It was held that no duty of care would be imposed on local authorities fulfilling their public duties toward the children in need. Now, my colleague Mr. Dory submitted that we do not believe the action of the police to result in the position of both control and responsibility. However, I would like to address the point that my learned colleagues addressed earlier. If you refer to that link 5, Lord Brown Wilkinson states, The first requirement is to show that the decision was outside the ambit of the discretion altogether. If it was not, a local authority cannot itself be in breach of any duty of care owed to the plaintiff. Again, in response to the submission by my learned friends, if we say the police did in fact take positive action to investigate this case, does a threatening text message and mail in the form of hate mail fall outside of the scope of the police and what their job is? If not for the police to investigate this matter, whose discretion would this fall under?
Well, I'm not 100% sure why we're looking at a public authority case, but if we're moving into that realm, do you know the case of Dorset Yacht?
I'm unfortunately not familiar with that case, my lord.
Let me just tell you then briefly, the Dorset Yacht case, some probation officers or some Borstal officers as they were in those days, took a bunch of youngsters out on a bit of a jolly, and while they were asleep, the youngsters decided to go out and wreck a whole bunch of yachts in a marina. And in that case, it was decided that there was a duty of care. So how do we odds a duty of care by a group of Borstal officers and not by a council?
So, my lord, in response to that, what I would submit is that case, these boys were, I'm assuming, under the guard of these men on the island.
Yeah.
Whereas in this case, the police, the scope of their practices is to the general public. It's not something quantifiable.
Okay, thank you.
In the case of Miss Preddy, this act of investigation falls within the discretion set out by Lord Wilkinson that a duty of care would not be owed to Miss Preddy. Your Lordships, may I move on to my second submission if you have no further questions?
Yes.
So my second submission is that the police officers would be greatly distracted from their primary obligations if held liable to all future claims. If I might direct your Lordships to the case of Hill and Chief Constable of West Yorkshire. Would your Lordships like a quick summary? So
no, we've already indicated we don't need one. This is, as I've said previously, the Yorkshire Ripper case.
Yes.
But it's true to say, isn't it, that in this case there was a general threat posed by a mass murderer being on loose in the vicinity, whereas here there is a much more specific threat in relation to an identified person and a potential identified victim. So there is quite a difference between the facts of Hill and those of the incident case.
Yes, my lady, that is true. What I submit, though, that is the Hill case established the principles that would apply to this case. If I may move on to my second submission, if that answered your question.
Yes.
So if you refer to link 7 in the bundle, page 407, as stated by Lord Keith of Kinkle,
Yes, well, efficiency is one thing, but why shouldn't the police be liable if they mess up and fail to protect an identified potential victim from an identified potential attacker?
My Lordships, I realize my time is lapsed.
That's
is it
fine,
okay if I
everybody's had
continue?
extra time, you can have extra time.
As my colleague, my learned friend said earlier, there was no, the two approaches to assume responsibility and control were not present in this case. And that is why we are distinguishing this case from that.
The quote you've used says the result would be a significant diversion of police manpower and attention from their most important function. Isn't their most important function to protect people?
Yes, my lord, that is their important function, but it is very hard to decipher or to draw a line in saying that at what point is this case here, was this the most important case in their workload for the day? These officers, these authorities are hired for the reason of fulfilling their jobs and owing a duty to the public. If we rely on them to do their jobs, if we allow the discretion that has been stated previously with the authorities, then I think it is fair to say that they are able to prioritize imminent threats to different members of the public.
Thank you.
Your Lordships, in the case of Ms. Preddy, there are 3 issues that would arise if the courts were to find it just, fair, and reasonable to impose a duty of care to the police. The issues being that first, we do not feel our public authorities would have the competence or the discretion to handle what it is they were to do, as you mentioned earlier, and I answered. The second is that the road is being paved for future claimants to follow and to seek compensation based on hollow claims that would further burden the system. And lastly, that the compensation paid would come out of the pockets of the taxpayers effectively. Do your Lordships have any further questions to the submissions that I have presented today?
Well, solely that your final point is really a make-weight, isn't it? If we decide the police should pay, the mere fact it's coming out of the public purse is neither here nor there, is it?
I think it goes to further solidify the argument that it would be a liability for the police and for the public as a whole if we allow this claim to go through. Your Lordships, if there are no further questions, I respectfully ask that this appeal be dismissed.
Thank you. I think you have the opportunity to rebut and to sum up.
Bear in mind it must be rebuttal, not a reiteration of your points of argument.
Your Lordships, are making 4 brief submissions in response to my learned friends. My learned friends submitted that there was a mere omission. However, I submit that in this current situation, there was a positive action, meaning that it undermined the public policy considerations underlying the decision to deny the third limb of capare. Secondly, that my learned friends relied upon the majority view in the Michaels case. The majority in the House of Lords is obviously binding on this court. However, I submit that that case was distinguishable for reasons I have stated earlier. Therefore, the minority view creates creates persuasive precedent, which I submit would help to rectify the current difficulty with establishing police liability. Thirdly, in terms of the police discretion to investigate different cases, they have already taken steps to investigate this case. Therefore, they have already taken that step. And finally, in terms of there being a distraction to the police from their primary obligation to be liable to everybody, the police would be the individual police officer would not be liable. However, the police would be vicariously liable, meaning that the individual policemen, I submit that they would not that would not weigh upon their minds that much.
Police officers hold the office of constable, don't they? Aren't they individually responsible for their action?
My Lords, I submit that in most of the cases involving the cases of this kind, it is the Chief Constable who is liable, who represents the police force rather than the Constable himself.
But he's vicariously liable.
Indeed, my lady. I have no further assertions.
Thank you.
Yes. We have time for a few moments.
Ben stood up, so he was very good.
Let me say, first of all, it was a very, very good moot. And I think you've all done particularly well. On the actual moot question, the appellants were never going to get close. They didn't stand a chance. But frankly, trying their best to be persuasive with dissenting judgments, it's not going to go down well in the Court of Appeal, but it gave us something to talk about, so well done for that. Let me go through a few negatives, just to give you some feedback, and this is not meant to be harsh or mean in any particular way. I think all of you spoke way too fast. You need to slow it down. It is quite ridiculous when you get into court. You will find that everybody is talking at this sort of speed, because people are taking notes. The judge is taking things down longhand 9 times out of 10. Watch his pen, see when you think he's ready for a bit more input, because if you go too fast, he's just going to keep stopping you and it's going to throw your flow. And the same applies when you get into senior moots. You're going to be expected to moot as if you were in a court or tribunal or in an appeal court, usually for the moots. I've got a whole bunch of I thinks from you guys. You're not paid to think, you're paid to give me submissions and not opinions. I think is an opinion. Okay, you must watch that because it will score you down all the time. Alex, you interrupted Dr. Elliott. That's definitely a no-no. In fairness, I saw you realising you'd done it as you did. Casey, you forgot about your co-counsel.
Yeah.
Throw him to the dogs. I think the Bedfordshire case, X versus Bedfordshire, is off point. You were giving yourself a hard time with that one. Dr. Elliott will talk in a minute about the case that we think you should have picked up on. Some technicalities. If I leave a room, if I stand up, if I scratch my nose, you blooming well stand up. You're sat there frozen. When I come back into a room, you stand up smart, and you button your jackets. You don't just sit there going, the old fool's back again, I wonder what he's going to say. Okay, it will not go down well. Now, the one advantage is, of course, there's usually a court clerk that will say, all rise, but in a moot, you're going to need to do it for yourself. So stand up, do your jackets. You all look very smart tonight. I'm very impressed with that. You all look nice and tidy. But stand up, do your jacket up, and look as if you're ready, and don't sit down until the judge sits down. Okay. Tracy, do you want to talk?
I know 3 of you are first years, and obviously you haven't done much law. But I think when you're constructing an argument for a moot, it's very important to have an eye, a very clear eye on the court you're appearing in front of, and the significance of precedent. Because you have the real problem is in that you have a Supreme Court judgment against you in Michael's, and it's a reasonably recent one. Now, you have 2 helpful judgments in the form of Lord Carr and Lady Hale. But the difficulty you have, the real difficulty you have, is you're in the Supreme Court. Now, your arguments might have more weight in the Supreme Court, where you can effectively say this is just wrong, reconsider it. But bear in mind what the Court of Appeal can do. You've either got to show us that they're per in QM, they don't really apply, or they didn't take into account a relevant factor. And what you kind of do is just ignore the majority judgment and go straight for Baroness Hale. which is tempting but could have opened you to savage pulling apart by a judge. On the other end of the scale, you had Michael's. It was a gift. It was easy. All you had to say is, well, the majority of Michael's said this. It's quite clear in this case that this falls within these criteria, and therefore police are not going to be liable. They are relying on the minority. You're the Court of Appeal. You're bound by the majority. Thank you very much. Sit down. So I agree with Adrian entirely. You didn't need X, but you missed a trick in not really using your big recent Supreme Court authority. So when you know a bit more law and you are more familiar with precedent, I think it's you kind of. I mean, Michael was the right authority, but you had a problem with it. And in fact, what you might have done is there are some cases which help you on informers, because they're more favourable with informers. So what I'd have done if I was in your shoes was I'd have said, well, she's tipped them off about him, and therefore she's analogous to an informer. Now, it may not be a good argument, but it's probably the best you've got on the facts you've got in the Court of Appeal. So I felt just think around your arguments perhaps a little more. The other thing is use of notes. I know you're all starting, you've done tremendously well. For first years, you know, this is fantastic. And practice makes perfect. Try to be aware that you engage with your audience and you're not reading and so forth.
The big problem with reading from notes is that when you get asked a question, if you're trying to work from a script and you get asked a question, suddenly you're off script, and then you're having to think about it, and it will throw you. If you know the case inside, my father-in-law, who's a senior lawyer, always says you have to live the case, live your case, know it inside out, be able to go to each page so that when the awkward judge says, well, I didn't see that, Lord Keith said such and such, you can go, well, yes, my lord, but if you go to page 72, Lord Keith also said, and so know it completely without having to look at a script. That's the way you win a case.
Lord Bingham, when giving advice to barristers appearing for the first time in the House of Lords, said when you were preparing a case, you should think of all the possible questions that a judge might ask you as you're preparing. Well, what are all the nasty questions? But I think one other way, apart from, practice makes perfect. The more you do, the better you get, the better you deal with notes, is come along, for example, the junior moot final, and see how other people cope, because you can say, well, that was great, that wasn't so great. You can look at the feedback. The one really good event I come along, which is a bit like modern day blood sports, is that we have a medical law mooting competition on the 5th of December. And we have a chap called Simeon Maskery, who's a QC, and he gives the competitors what has to be like the worst day in court ever. He's not interested in speeches. But if you watch someone like that, it gives you a really good idea of how to handle or how not to handle interventions. Because we weren't too bad, but if you do external competitions, sometimes you get judges that are a nightmare. Sometimes in court you get judges and they're a nightmare. I once did a case, it was so bad, and it was a return, so it was a case I got the night before, it wasn't my case. It went so badly, I thought the judge was going to make me pay the cost personally. It was that bad.
The great thing is that a judge, the second he's made a judge, forgets he was a barrister and was in front of judges like him themselves. It's a bit like your parents. You always think, I'm not going to do what my parents did. I'm not going to make my kids clean up the room, etc., etc. And then as soon as you've got kids, you say, get up there and get that room clean. And judges, they just turn evil for some reason. The minute that they get that gig, they're really awkward. And then afterwards, they'll be having a chat with you and say, oh, it wasn't too hard on you. So, they do it out of theatre sometimes, I think. But how did you do? We've been asked to suggest who won on the evening, as it were, with their skills, and then who overall was the most confident mooter. And I think Dr. Elliott and I agreed that the respondents in this case put up the strongest fight all in.
Really, by a very narrow margin. The
Oh.
stand-up was terribly good on both sides.
Yeah.
I mean, we're amazed to hear that 3 of you are first years. I mean, really, really should be very pleased with yourself.
And to show you just how close it was, the overall most confident mooter, who I think I probably gave the hardest time to, he came back bouncing each time, was Alex Cotton.
Well done.
Thank you.
And
Well
do carry on
Well
mooting.
done to
'Cause-
all of you.
yeah. Well done.